Dalija Pinho. By Hakimi Abdul-Jabbar or A.J. Hakimi. Advocate and Solicitor, High Court of Malaya. Practicing Malaysian lawyer. On 7th of July 2019 UTC +8 at 11:45 p.m. A short legal opinion podcast. Relevant international legal instruments and the protection and redress for victims of crime and human rights violations. The SUHAKAM finding on April 3, 2019 and other victims of crimes in Malaysia. In light of the damning finding of the SUHAKAM inquiry dated April 3, 2019 on the enforced disappearances of 2 individuals by agents of the state, it is of essence to relate 3 relevant international legal instruments that imposes general legal duties on Malaysia, namely 1. Universal Declaration of Human Rights 1948, and 2. Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power 1985, and 3. Vienna Declaration and Program of Action, 1993. This podcast deals with 2 basically distinct, but also clearly related issues, namely protection and redress for victims of crime such as myself, on the one hand, and protection and redress for victims of human rights violations, on the other. Conventional crimes are committed by individuals in their private capacity against national penal law, and acts constituting human rights violations which fall under the category of crimes are committed by organs or persons in the name of or on behalf of the state, for instance by the government, parliament, the courts, prosecutors, police officers and other law enforcement officials. As will be seen, however, governments may in specific cases, be responsible for the acts of private individuals. These acts may constitute violations of the fundamental rights and freedoms of persons under international human rights law and or under domestic constitutional or ordinary legislation. Admittedly, however, this distinction between victims of crime and human rights violations is not always clear-cut, but it serves as a convenient point of departure for the presentation of the legal problems dealt with. International law does not regulate in detail the question of protection and redress for victims of ordinary crime, although attempts have been made to increase the focus on the plight of victims so as to encourage and spur governments to provide them with adequate help and support. Limited rules that do exist in the hope that it may inspire further discussion of the problems facing victims of crime, the main purpose being to increase participants' awareness of the importance of paying due attention to their feelings, needs and interests at all stages of the legal and judicial processes. It must be pointed out that conventional crimes cover not only more traditional crimes such as ill-treatment, murder, trafficking, sexual and other abuses, theft, burglary and so forth, but also various kinds of organized crime and corruption, as well as, for instance, the relatively new category of cyber crimes. On the other hand, it will not be possible to deal in detail with the various interests that different categories of victims have or may have, and the chapter will therefore deal only, in relatively general terms, with the problems of victims of crime. The protection and redress for victims of crime are addressed in relevant legal provisions at the universal level. While there is no universal convention dealing with the rights of victims of conventional crimes, the United Nations General Assembly adopted, in 1985, the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, and as such it defines the notion of victim of crime and abuse of power and specifies victims' rights of access to justice and fair treatment, restitution, compensation and assistance. Paragraph 3 of the Declaration states expressly that, the provisions contained herein shall be applicable to all, without distinction of any kind, such as race, color, sex, age, language, religion, nationality, political or other opinion, cultural beliefs or practices, property, birth or family status, ethnic or social origin, and disability. According to paragraph 1 of the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, the term victims means persons who, individually or collectively, have suffered harm, including physical or mental injury, emotional suffering, economic loss or substantial impairment of their fundamental rights, through acts or omissions that are in violation of criminal laws operative within member states, including those laws proscribing criminal abuse of power. This definition covers many categories of harm sustained by victims as a consequence of criminal conduct, ranging from physical and psychological injury to financial or other forms of damage to their rights, irrespective of whether the injury or damage concerned was the result of positive conduct or a failure to act. Paragraph 2 of the Declaration clearly states that a person may be considered a victim regardless of whether the perpetrator is identified, apprehended, prosecuted or convicted, and regardless of the familial relationship between the perpetrator and the victim. According to the same article, the term victim also includes, where appropriate, the immediate family or dependents of the direct victims and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. Thus, Provisions of the Declaration, in full consistency with the principle of equality enshrined in Article 8(1) of the Federal Constitution and the prohibition of discrimination and bias under the rules of natural justice that form part and parcel of the same Constitution are applicable to all. Whether a person is a victim of crime or human rights violations, conditions have shown the essential role of judges, prosecutors and lawyers in responding effectively to the problems, needs and rights of the victim concerned. Members of the legal professions must not only be courteous and show understanding, they must also have a sound knowledge of human rights law and be prepared at all times to act impartially and independently in the pursuit of justice. Indeed, without an independent and impartial judiciary, as well as independent prosecutors and independent lawyers who are given the liberty to act promptly, vigorously and effectively in response to alleged human rights violations, human rights will largely remain a dead letter. It is for all states to grant the legal professions this independence and impartiality, and for the members of the legal professions to take the lead in enforcing human rights law by vigorously investigating and prosecuting acts that violate individual rights and freedoms. Impunity for human rights violations is one of the most serious threats to the full enjoyment of the rights and freedoms of the individual, and constitutes a violation of a state's legal duty to ensure the effective protection of these rights and freedoms. Non-prosecution of criminal acts such as thefts, torture, abduction, disappearances and the arbitrary taking of human life etc., have a particularly devastating impact on the victims and their next of kin, as well as on society as a whole. A culture of impunity also widens a gap between those close to the power structures and others, who are vulnerable to human rights abuses. The increasing difficulties in securing justice drive people to take the law into their own hands, resulting in a further deterioration of the justice system and new outbursts of violence. While international law is somewhat lacking in legal provisions relating to the rights of victims of ordinary crime, the opposite is true in the case of victims of human rights violations. In this area, numerous legal provisions and a comprehensive jurisprudence provide a rich source of knowledge and inspiration for the legal professions. States' legal duty to prevent, protect, investigate, prosecute, punish and redress human rights violations has been given ample coverage in this chapter. Although there has been a tendency to focus on the right to life and the right to freedom from torture and other forms of ill treatment and violence, the same obligations exist with regard to the whole spectrum of human rights. As rights are interdependent, their effective protection cannot be examined in isolation. Victims, for instance, must be able to speak freely in order to vindicate their rights and must enjoy respect for their correspondence in order to be able to communicate with legal counsel and so forth. This intrinsic relationship among rights becomes particularly relevant to the enjoyment and crisis situations of those rights that cannot be derogated from in any circumstances and others that can, in principle, be derogated from.